The Honorable United States Court of Appeals for the First Circuit is now in session. All persons having any business before this honorable court may draw near, give their attendance, and they shall be heard. God save the United States of America and this honorable court.
You may be seated.
Court is in session. Today's cases will be called as previously announced in the first, and the times will be as allotted to counsel. The first case today is number 23-1951, Regina M. Thornton versus Ipsen Biopharmaceuticals Incorporated. At this time, would counsel for the appellant please introduce himself on the record to begin?
Good morning, Your Honor. May it please the court.
Mind just moving the mic up a little bit higher? Yeah,
Is that better, Your Honor?
much better.
Good morning, Your Honors. May it please the court. Richard Chambers, Jr., and with me at the counsel table is Attorney Joseph Spinelli. We represent the appellant, Regina Thornton.
May begin.
Thank you, Your Honor. Your Honor, in my brief, this is a case that was before the lower court.
You ask for rebuttal.
Oh, I'm sorry. Yes, I'd like to reserve 3 minutes for rebuttal.
You may.
Thank you, Your Honor. Your Honor, this is a case that was brought in the lower court. It was actually brought in the Massachusetts court. And the appellant was employed by Ipsen Pharmaceuticals. And during the time of the COVID vaccine, Ipsen the appellee put in its own vaccine policy that required all of its employees to be vaccinated. And the appellant, she was afforded the opportunity to put in a religious exemption, and she did that. And
when you say its own, doesn't that in and of itself cut against your argument that there was state action?
no, Your Honor, because part of my argument, and I know that the appellee says that, yes, they did implement their own, but it was 2 days before the federal mandate. And I would submit that they were warned that the federal mandate was coming. They knew it was coming, and that's why they implemented their own policy. So I still make the argument that there's state action.
In the record that supports that causal connection?
There is not, other than the fact, Your Honor, that had this matter proceeded to discovery, I think we would have been able to prove that, but it was summarily dismissed pursuant to a 12B motion. So there is nothing in the record other than the contention that Ipsen put theirs in 2 days prior to the federal one. Moving on, Your Honors, the appellant defendant at the time removed the state action to federal court. We had amended the complaint, and I state that in my brief. So we're dealing with the second amended complaint. It was the appellee then filed for a motion, 12B motion to dismiss. The lower judge allowed us oral arguments, heard our arguments, and dismissed the case. And I would like to submit to Your Honors that there's 2 counts with respect to the religious claims. And the 2 counts that I believe, and we cite in the brief, is Title VII and 151B. And with respect to 151, General Law, Chapter 151B, which is the statutory definition found, states, creed or religion is defined as any sincerely held religious beliefs without regard to whether such beliefs are approved, espoused, prescribed, or required as by an established church or other religious institution. And
I got a question. When pleading standard, that's perfectly fine under 151B, but shouldn't the complaint here have stated more? Because basically what it says is, I have religious beliefs and these are private. Couldn't the complaint have said, I have religious beliefs, they're private, and these are my beliefs, and X, Y, and Z, and this is what I observe, a little bit more beef? Or is that just sufficient, simply everybody saying, well, I have religious beliefs?
well, Your Honor, I would say that
Why isn't it conclusory?
That's exactly what I'm asking.
okay, and I would say that it's actually not, because when you read my brief, you're going to see that the defendant put in an opposition. And when the appellant was employed by Ipsen, she filled out a form. It was a very detailed form. And I would submit that at this stage of a 12B, it's notice pleading and it's facts most favorable. And
Okay, but couldn't have the complaint referred to that notice that she submitted, because it's not in the complaint.
Your Honor, I would say it could, but
'Cause you could have attached it perhaps to the complaint or incorporated by another paragraph.
well,
but-
we did incorporate it. We asked, and the judge did consider it. And she states in her motion that she gave it credit and considered it. And she actually spells out that Ms. Thornton had stated that she had more than just deeply held religious beliefs.
When you say you incorporated it into the complaint, what are you referring to?
On the motion to dismiss, Your Honor, I argued it, and she said,
There's nothing in the complaint that makes reference to it though, right?
no, there is in the opposition. It's part of defendant's opposition. They
They attached it,
attached it themselves, yes, Your Honor. And it's fairly detailed.
and then the district court relied on it as if it was
It did.
before her in the ruling.
She actually, the district court judge actually found that the religious beliefs were credible. She gave him credit. She wasn't saying that I don't believe that she doesn't have religious beliefs, but what she did say was it's not enough, which is what your honors are alluding to. Just simply saying deeply held religious beliefs.
Is there
Said
any,
it was personal.
I'm sorry, Judge?
Court said it was a personal belief, not a religious belief based upon what she submitted.
You're right, Your Honor. And that debate's been going on through history, and it's for someone that believes no evidence is
There's gotta
required.
be a difference. You have
Well-
religious protections, you don't necessarily have personal protections.
Yeah, well, someone who doesn't believe, no evidence is enough. And in this case, she stated deeply held religious beliefs. She stated she was a Christian. She was a member of a faith. And I would say,
she says that the vaccine would defile the body and that
Yes.
the thing that would be inconsistent with God's command. Is that right?
that her body is a temple and taking the vaccine would defile that relationship with the Lord. Yes.
And so, just so I'm clear, was there any reference to the existence of the filing?
I'm sorry, I didn't hear that, Judge.
Was there any reference to the existence of the filing of that form in the complaint?
I think in the facts, we say that that she went through she had the ability to file for a exemption.
And it says that she filed a form. And does
Yes,
it say
it
what,
does.
that she set forth her belief in the form, or just says she filed the form?
I believe I say in the facts that she set forth her beliefs in the form, and then we say she had deeply
And
held.
in the answer, they then attach the form, and then the magistrate judge, in deciding the 12B6, treats the form as if it was before.
Yes, that's correct.
Okay, so if we take the record for purposes of the 12B6, there's two possibilities. We could either say the record is just the complaint itself, which doesn't say anything other than that she has a religious belief. Is that right?
A little more than that, but that's right. But if you take the
If we
form,
take The form, then we have the account where she says, here's the religious belief. It's, I can't take the vaccine because God commands me not, my body's a temple, and this would defile the body. So the district court said even that is not enough to set forth the religious belief. Why is that wrong?
it's wrong, Your Honor, because religious beliefs should be taken to the person, each person. If you're a member of, say,
I understand that if she stated a religious belief, there would be a problem with then doing a whole lot to question it. But I think as Judge Thompson and Judge Helpy are asking, is that enough to state a religious belief? I mean, there are courts that she cites, the magistrate judge cites, that say just saying, I have a religious belief, I can't take a vaccine, is not sufficient to have shown that your belief you can't take the vaccine is a religious one. I know the 10th Circuit seems to say, as long as I say, yes, it's religious, that's enough. But there's a dissent saying that's a misreading of precedent. The 8th Circuit says, my body is a temple, that's enough.
yes.
But then there are these district court decisions saying that things sound a lot like this are not enough. So how do you
Well,
think we're supposed to think about it?
I'm saying that at that point with respect to a 12B motion, that we're notice pleading and the facts are taken in the light most favorable to the plaintiff, I say it is enough, Your Honor.
What more is there that's going to come out? I mean,
Well-
it's a little strange to say it's a religious belief, but you'll find out later why. I mean, we're trying to figure out, has she plausibly pled it's a religious belief? So what is she saying here
Well-
that makes it plausible it's a religious?
It's the form that she submitted to her employer where she states it pretty succinctly. And
In the form specifically makes it a sincerely held religious belief. What is she saying in the form that makes it so? Because that's what the employer has to determine
right.
if it really is what she says it is.
She says that, first of all, she's never taken the flu shot for over 20 years.
So does that mean that she doesn't take aspirin? Does it mean that she's just limits it to vaccines? I mean, what is there some specific, if she's a Christian, assuming that her beliefs flow from the Bible, is there something in the Bible that says you shouldn't take shots?
I don't think that the Bible predicted the COVID-19 outbreak. I think the tenets of the religion shouldn't be.
One way to ask it is, she does say that this would defile the body.
Yes.
And that would be inconsistent with God's command. What she doesn't say is what it is about this that defiles it relative to anything else that she encounters in the world, right? So she ingests all kinds of things. Presumably, she's not saying everything she ingests defiles the body. So to understand the religious belief, one thing she could say is, what is it about the vaccine that's defiling the body?
And I think if we taken as a whole, where she says, I have a deeply held religious belief, I'm part of a religion. She's not saying like in these other cases that got dismissed, that God told me to do this. She's saying, I'm part of an organized religion. This is my belief. I believe if I take the vaccine, it's going to defile my body, and it's going to.
Just vaccines that defile. I mean, does Diet Coke defile?
No, Your Honor, it doesn't, because this
That's what I guess the question is, how can I tell that from her filing? In other words, she has stated that it defiles the body, but what is, and this may be irrelevant for purpose of what we're allowed to inquire about. And I guess if you can, either would be helpful to us to explain why it's irrelevant. In other words, why the case law makes sense to conclude none of our business why it defiles. She said it was a religious reason that it defiles.
Well,
or there could be some requirement that she say a little bit more to explain how that belief is a religious belief.
I would say that she did explain it enough and put it in the form she had to fill out for the exemption, which was denied by her employer. She put them on notice of that it was a religion. And I would submit that when she makes the temple, my body is a temple argument, it's that almost like natural versus artificial immunity. The vaccine is man-made mRNA. It changes your DNA.
Does she say that?
She doesn't, but I think she also says this is difficult for me to articulate.
You must be saying, right, you must be saying she doesn't have to say that.
Yes, she doesn't have to say that.
Do you have a reason?
Yes.
Why is it that you're saying she doesn't have to say that?
Because on a 12B motion as dismissed, Your Honor, with all due respect to the district court judge, it's not her job to decide the facts at that point. This is up for the trier of facts later on, whether she really has such a belief.
There's got to be a plausible statement for us to get a hook on.
I'd say, judges, I'll leave you with this, that stating I'm part of religion, I have a deeply held religious belief at this stage for a 12B motion is enough.
So the fact that she said it defiles the body is, in your view, irrelevant to the.
No, it helps because it was added, because it gives the court more information.
What is the information that's giving that you think is relevant to
that?
Whether it's religious.
That just came out of the 8th Circuit, that my temple is my body argument. I think that's enough.
Thank you.
Thank you, Your Honors.
Thank you, counsel. At this time, counsel for the appellee, Mr. Rosenfeld, if you could please introduce yourself on the record to begin.
Good morning. Jonathan Rosenfeld. And at counsel's table, I have Michael Lenzi on behalf of appellee Ipsen Biopharmaceuticals, Inc. May it please the court. This is a case involving a former Ipsen employee who refused to take the vaccination. Per Ipsen company policy, when the pandemic was raging in 2021.
You agree that if it's a religious belief that she has alleged, then the claim goes forward on Title VII, right?
If she was able to establish that her religious belief conflicted with the employment requirement of vaccination, that's the pleading standard, and it's a two-pronged standard. And counsel for Ms. Thornton have asked in their papers for you to ignore that part of the standard. They want you to just look at, does she sincerely hold a belief?
Well, if the belief is she can't take the vaccine, then it would conflict with the requirement to take it, wouldn't it?
In terms of the pleading, though, you have to plead more than a tautology or a conclusion, I can't take the vaccine. You have to be able to connect it, that not only am I a member of a particular religion, she doesn't even say what denomination, but you also have to be able.
Being just saying I'm Christian enough.
It may be, but it's again, it's just another infirmity. But the judge below took it and said, yes, she believes in God.
Do you think the Eighth Circuit was wrong in their decision?
I do.
Why?
The Eighth Circuit was wrong because it's contrary to the jurisprudence in most of the other circuits, including here.
10th Circuit seems to come out even more strongly than the 8th Circuit.
They do, but if you look at the Third Circuit, the seminal decision of Fallon, in which the court made it very clear that personal conscience is not
Right, but here she
the same.
says that she's not acting on personal conscience. She's acting on a command from God not to defile her body. Why is that not enough?
Right, because, and again, I would have the court take a look at the McCarthy case with Judge Stearns, who addressed this exact issue, where it was a COVID-19 vaccination case, and Judge Stearns said that, well, it was the "my body is a temple" argument.
But did the plaintiff there say that God had commanded that she not defile her body because it was a temple? I don't believe those words were in the complaint in that case.
I think I'll quote from Judge Stearns. She said, I believe that receiving this vaccine would be a violation of conscience as a Christian who believes in the Bible, specifically the King James Version. I feel this vaccine would violate the principles laid out in God's work. I believe my body is a temple, so it did say that, for the Holy Spirit.
That God commanded I not defile it.
No, but said it's a God-given responsibility and requirement for me to protect the physical and spiritual integrity of the body.
Judge Stearns would come out the same way as the magistrate judge on this same record. Why would Judge Stearns be right in doing so? And why are the 8th and 10th Circuits wrong?
Well, and Judge Stearns explained his reasoning in that case. He said that if you went by the dictates of your own conscience, which that's what Judge Stearns, that's how he came out with this, that really what you're saying, even though you're saying my body is a temple, that you're saying that you have to follow the dictates of your conscience. And if that was the standard.
If I say I'm not following the dictates of my conscience, I'm following the dictate of a command from God. How can a court say, no, that's just your conscience?
Because it is not sufficient to simply say, I had a conversation with God, or
What needs to be added to make it sufficient?
What needs to be added is that there has to be a connection between the particular religious belief and that belief actually says that I'm prohibited from taking a vaccination. You have to make that connection. And we've cited
something in the Bible that specifically says don't do this, as opposed to, the Bible tends to speak in terms of generalities.
There has to be something either
You're going to find a command not to take a vaccination in the Bible.
I don't believe so.
No, but you have to be able to make the connection, Your Honor.
Why, that's what we're asking. Why is she not making the connection when she says that the religious belief is my body is a temple, and the further religious belief is God has commanded I not defile it? And my understanding is that the vaccination would defile it. Is it that last step that she hasn't explained why the vaccine would defile it?
No, it's that she hasn't been able to identify that there is actually something that commands her not to take the vaccine.
What you're saying is she should have pleaded, and this is just, I'm not quoting the Bible, just making this up, but for example, she would have to say, according to the Gospel of John, X part of the Gospel, it says X, Y, or Z, and I'm following that command. She should have pleaded something like that, are you saying?
Something like that would be a step in the right direction. But, we cited 12 cases, vaccination cases, which are my body is a temple type argument. And in all of those cases, the court has said those are personal preferences, those are moral teachings, those do not make that causal connection. And Judge Saylor in
There's two possibilities. There's the possibility as to whether the person is communicating to us that they understand the belief to be commanded by their religious belief. God has said it, etc. There's the further point you seem to be making is then you have to demonstrate that there's some organized religious text that supports the conclusion that you're right in saying that there's a teaching that would support the idea that God's commanded it. I don't know of any cases that say that.
the cases, if you look at the Griffin case, you look at the McCarthy case, the court says it's not enough to simply say, this is my belief, my body is a temple. We've cited 12 cases. And the key thing here is that the only thing that they've said is my body's a temple, this would defile my body, but it doesn't say, and I can't.
One possibility is you're saying you have to point to some religious text that would support the belief. If I thought that would put a court in an odd position of then having to scrutinize texts and require you to have a religion that's got some foundational text that I could look at that would plausibly support it. Is there anything else that you think instead would be enough to show the religious belief?
Well, it could also be that there is a practice, you have cases with religion dealing with the Sabbath. And that's another way that one could show that there was an actual practice. But it's not enough to simply make a conclusion and say, I don't have to follow the employer's requirement because this is my belief.
Suppose she said, because I think my body's a temple, I only eat organic food and nothing else. Would that take it over the threshold of plausibility?
No, because that would just be a personal preference. There has to be something about the religious belief that connects it to, and I'm not supposed to have a vaccination.
I'll put it this way. We'll play a couple steps out. You tell me if it's still incomplete. God commands that my body is a temple. God further commands that I not defile the body because it's a temple. And God commands that puncturing the skin with a foreign substance and injecting it would be to defile it. Is that not enough?
Well, if there was a specific dictate that one not puncture the skin.
Is that not enough? She says it's a religious dictate coming from God. That's not enough?
But she doesn't say that. So in Exhibit A and Exhibit B.
That last step, is that what's missing?
Well, that's one of the things that's missing.
What else?
Well, the other thing that's missing here is that she does not in any way talk about this specific vaccine or vaccines in general. She makes nothing about connecting the vaccine to her religious belief. And that's the cornerstone of the 12 cases we cited, and particularly.
So the problem she has is apparently she's from the complaint. She's not a member of she's Christian, but she's not, a Catholic, or she's not a Greek Orthodox, Greek Orthodox, and says the Bishop of Constantinople just said that nobody should vaccinate himself because that defiles. If she were part of an organized religion that says, then it'd be easier for her. Are you saying that?
You don't have to be part of an organized religion, but you do have to make that connection. And indeed, I would implore you to look at the Griffin case where Judge Saylor says there is an obligation on the part of the employer and the court to screen things, that you don't have to take because this is the argument they're making, just take it on face value. We say that automatically, this is my body is a temple and I have a sincerely held belief. No, the court's obligation, as is the employer's, is to look at it and say, is there really a religious belief against this particular employment requirement? Because if not, and this is why the conscience argument comes in, then an employee can simply say anything that they don't want to do or any policy violation that they make, that was God's teaching.
Appreciate the point. There's just a question of how many steps have to be completed to make the argument. So, in religious school, there's no end to the questions of why that you could ask about any religious practice. Why do you got to do it? Why? So how many whys do we have to ask here? I say, I don't want to take the vaccine because God commanded it. You say, well, you're entitled to ask why. Why? In what way did God command it? Then she says, well, because my body's a temple. So then we say, well, why does that matter? And she says, because it would defile my body if I took the vaccine. Then you say, that's not enough. Well, how many more questions do we have? Then she says, well, because it would be wrong to puncture the skin and ingest it with a foreign substance. Well, why is that the case? Would you not do a blood transfusion? You could go on and on and on. I don't read the cases to say it's an endless Sunday school class. So I'm trying to figure out what is the point at which the court is supposed to relent, because we are supposed to respect sincerely held religious beliefs, versus the point at which we have to inquire to make sure it's not a personal belief, it's a religious one.
Well, I read it as there's a pleading standard, and there is a certain modicum of facts that have to be pled to get you over that pleading standard. And what the courts have said is it's not enough to say, my body is a temple, I'm not supposed to defile my body. That you have to be able to show that the particular employment requirement, in this case vaccination, that conflicts with my religious belief, and you have to articulate that to get you over the hurdle.
And this is hypothetical. Let's assume you were Ms. Thornton's attorney, plaintiff's attorney. How would you then plead to make sure it survives the 12B6 stage? What would you have pleaded, in a nutshell?
Well, Judge Helpe, I wouldn't have taken this case in the first place. But if
Let's assume the court appointed you and you had to do it.
Friend of the court.
Okay, friend of the court. What I would have to do is to make some sort of showing that there is a principle or tenet of my religion that I can point to, that this is either, commanded to me in the scripture, this is part of the rituals that we do. I'd have to be able to show that there is a tenet or principle. Those are the words that are used in the Griffin case and in many of the other cases that we cited. So I've got to identify that tenet or principle that says you can't vaccinate, or Judge Barron, as you said, you can't puncture the body. And I have to allege that because I have to let my employer know that I have a real reason, and not simply that, I woke up today and decided, I don't want to get a vaccination. So what I'm going to say is I'm going to just mouth these words, that my body is a temple and I don't want to pollute that temple. As Judge Thompson, as you said before, how do we know? Drinking a Coca-Cola, is that different than if I'm getting a vaccination? Again, the burden is not the employer's, and it's very difficult for both an employer and a court. But notwithstanding that difficulty, that doesn't absolve the employer and the court from engaging in that analysis. The burden was on the appellant to put, and we gave her 2 bites at the apple. So she initially, in her complaint,
last thing, because we're over time, but do you agree that the form she filled out is part of the record for purpose of deciding this in light of how the district court magistrate judge?
It is part of the record because she referenced an Exhibit A, which was her first letter, where she referenced about her body being perfect. She then gave a self-styled appeal, even though we don't have an appeal process, and did an Exhibit B. That just amplified the same thing, but didn't make that causal connection between.
We should treat that as part of the complaint.
You should treat it as part of the complaint, but it doesn't change the outcome of the case.
Just briefly talk about the state action piece before you sit down.
I'm going to let my co-counsel talk about that, Your Honor.
Thank you, counsel. At this time, if
We're just going to hear from quickly on the state action. Go ahead.
please introduce yourself on the record.
May it please the court, my name is Michael Lenzi, counsel for the defendant appellee, Ipsen Biopharmaceuticals, Inc., addressing just the state action question. The U.S. Constitution protects individuals against state action, not the conduct of private employers. The second amended complaint does not include any factual allegations suggesting that Ipsen is a state actor under any of the applicable tests. There's nothing in the complaint that references the executive order or that says Ipsen coordinated in any way with the U.S. government when it was adopting its policy. Further, Ipsen's vaccination policy went into effect 2 days before the executive order was issued. So that shows that there's no causal relationship between
Again, the executive order, we know it was issued, but an executive order like that is going to be issued. I think it's something we can all experience. We know days before when the governor is saying, I'm going to be signing this executive order effective XYZ day. So isn't there enough of a connection there, or you have to wait till the actual order is issued? Because if I know it's going to be issued, I can give you an example. The courts, we knew when these orders were going to be issued. We started moving along just to make sure by the time they're issued, we were ready for those executive orders. So isn't that state action in that sense?
No, Your Honor. And first, there's nothing in the complaint that alleges that Ipsen foresaw this executive order coming and acted on behalf of that. So that's not in the pleadings. It's referenced in the briefing, but not in the complaint itself. But even assuming that that was alleged, that Ipsen saw the writing on the wall, as it says in the brief, and implemented its vaccination policy because of that, that would not constitute state action. A private employer does not transform into a state actor merely because it's complying with an executive order or a federal regulation. If that were the case, then any company that followed the law would be considered a state actor. And the U.S. Constitution's protections simply don't sweep that broadly.
Let me ask this argument. I believe in your brief, you say it was not raised below, correct? The state actor.
Can you repeat the question, sir?
I believe in your brief, you mentioned this argument was not raised below. Am I correct?
No, Your Honor. The state action claim was raised below.
Okay, that was raised.
But the argument that this was a violation of the Massachusetts Declaration of Rights.
Okay, that's.
The court found that there is no such private right of action under the Declaration of Massachusetts, under the Declaration of Rights. However, in the briefing, Ms. Thornton has tried to refashion her claim as not one under the Declaration of Rights, but instead one under the Massachusetts Civil Rights Act.
Okay, that's.
However, even under that refashioning, her argument fails because she has not established the pleading standard under the Massachusetts Civil Rights Act, where you need to show that there's an existing right that's guaranteed by the Constitution or federal or state law, that there was interference with that right, and that interference was due to, quote, threats, intimidation, or coercion. Ms. Thornton has failed to meet any of those prongs. Most notably, this court specifically held in Nolan v. CN8 that the threatened or actual loss of at-will employment, which is what's alleged here, does not constitute coercion for the purposes of the Massachusetts Civil Rights Act.
Thank you.
And for those reasons, this court should affirm the lower court's decision. Thank you.
Thank you, counsel. At this time, counsel for the appellant has a 3-minute rebuttal. Please reintroduce yourself on the record to begin, sir.
May it please the court, Richard Chambers Jr. for the appellant, Regina Thornton, for brief rebuttals, Your Honor. Very briefly, my brother had mentioned a Judge Saylor case, the Griffin case, and I just like to ask you to take into consideration the other Judge Saylor case, which is the Together case, where Mass General Hospital employees, nurses, there's literally, I'm paraphrasing, but literally 200 plaintiffs in that case. And that case made it past 12B motion to dismiss and summary judgment with Judge Saylor. And that's the one where he says you should take each plaintiff on an individual basis. I went and looked at that complaint, and the majority of the pleadings in that complaint, they simply said, I have a deeply held religious belief. and that has passed the 12B and passed summary judgment. I'd ask your honors to consider that. Thank you.
Thank you, counsel. That concludes argument in this case. Counsel's excused. Before we go back on the record, is Attorney Edward West or West here? Yes. Yes? Okay, great. Thank you, sir. Next case is going to be Roberge versus Travelers. Judge, I'll go ahead and put it back on the record if that's okay.
Yeah, please do.
The next matter, number 24-1040, Cynthia A. Roberge versus Travelers Property Casualty Company of America. At this time, would counsel for the appellant please introduce himself on the record to begin?
Good morning, Your Honors. Jim DeAmbra on behalf of the appellant Cynthia Roberge. May I request 13 minutes or 2 minutes rebuttal? As the court is aware, we're before the court on appeal regarding the denial of the appellant's cross motion for summary judgment and the granting of appellee Travelers' motion for summary judgment. By way of background, this case was filed in state court, removed by Travelers to federal court. The district court heard the matter on diversity, and as this court is well aware, it must apply as best it can in forecast Rhode Island law while sitting in diversity. The basis of our appeal is essentially two grounds. In our opinion, quite clear Rhode Island law. Ms. Roberge was an employee of the state of Rhode Island while operating her own personal automobile and was involved in a very serious accident. There's two main points that are not in dispute. One, she was an employee of the state of Rhode Island in that she was in the scope of her employment at the time of the accident. That is conceded by Travelers. Travelers indicated that in their denial letter in coverage, and they did not oppose the appellant's statement of undisputed facts on that point. So it's uncontested. Secondly, uncontested is the fact that Travelers' policy contained a special endorsement. And that endorsement was an employee as an insured endorsement. And what that endorsement did was make her automobile considered a covered auto at the time of this accident by the endorsement. So there's no doubt that if she was involved in this particular accident, say, for example, she rear-ended someone, she would be entitled to liability coverage on a primary basis from Travelers' policy pursuant to that endorsement. With that backdrop, we brought the case and we made two main arguments. One is under the Rhode Island Supreme Court case of Martinelli versus Travelers, that she should be considered a named insured as an employee operating a motor vehicle in the scope of her employment.
You don't disagree that the Martinelli language is a little, shall we say, squiggly?
Martinelli by itself, yes, but I would submit, Judge, there were three cases thereafter. In fact, Medeiros 1, Medeiros 2, and Medeiros 3, where in Medeiros 1 and 2, the Supreme Court addressed the issue. In fact, I was the defense attorney for the insurers in Medeiros 1 and 2. I am very familiar with this issue. In Medeiros 1 and 2, the issue was the application of the Martinelli exception. The court knows from the briefs, these were two gentlemen coming back from a Red Sox game. They were shareholders that owned two different corporations, West Valley Inn and Perinos. Just like in this case, the Travelers' policy attempt.
Justice Indeglia was was pretty definitive that there was a Martinelli exception.
He is, that's the third case, Judge. So we have two Superior Court judges. Judge Hurst was Medeiros 1 and 2. Judge Indeglia was Medeiros 3. So Judge Hurst, I handled 1 and 2 before Judge Hurst. She applied the Martinelli exception. In that case, there was no evidence of scope of employment. So the motion was granted for the insurer.
Just want to understand if maybe I'm getting confused.
Sure.
The named insured here is not your client.
I agree.
Okay. So then the Martinelli exception means even though they're naming somebody else, you can understand that to include the employee.
That's correct.
Okay. But what do we do when the policy, even for the named insured, only provides the coverage as to certain vehicles?
I agree. A reading of that policy says that. I don't disagree with that.
So even if it got to employees covered, it wouldn't help if the employee is not in the covered car.
I disagree.
What does Martinelli say that talks about that question?
So if you look, and I included in the appendix the briefs that were filed in Martinelli, it's just like this case, Judge. In fact, this case is even better than Martinelli because at least in this case, she qualifies for liability purposes.
Put aside, I understand that
Okay.
argument. Put aside the liability provision. What in Martinelli suggests that a policy that covers the named insured only as to certain automobiles, even if it could be read to cover employees when they're on the in those automobiles?
Well, and
What does Martinelli say that suggests it then also covers employees in different automobiles than the policy references?
Martinelli, just unlike this case, attempted to limit coverage only to covered autos. So why would the Supreme Court indicate the availability of that exception if,
Because an employee could be in a covered auto too, right?
but not in that case? Same thing.
But they didn't hold that it did cover that case. I mean, there's two different issues. There's the question of, can something that doesn't name employees apply to employees? Martinelli says, yes, it may well, just like it may apply to shareholders. Why would it then also say, and it applies to cars the policy doesn't reference?
If I could give you the backdrop very quickly, Judge. So the basis of Martinelli, as well as a lot of cases in other jurisdictions, when a corporation is named as the named insured, it's not an individual. The corporation could never get the benefit of bodily injury. So a named insured, class 1 insured, you don't necessarily have to be in a covered auto to get that coverage.
Right, but the statute that's the grounding for Martinelli, which is the requirement to provide uninsured coverage, doesn't require you to provide it as to all cars. It requires you to apply it when you're providing insurance for the car covered, I would have thought, right?
That's not what the statute necessarily says. The statute says no policy insuring against loss and defines a policy insuring against loss as a primary policy. The Rhode Island Supreme Court has says
Well, when I buy car insurance, I usually buy it with respect to certain cars. Not any car I happen to
don't
be in.
disagree with that.
So are you saying that any car I'm in, now the uninsured motorist coverage applies?
Only if there's a nexus between the scope of employment at the time of the accident. That's the whole
But
key.
where is that in Martinelli? That's what I'm not seeing. I don't see that in Martinelli. I don't see it in Medeiros. And did the issue even arise in the Superior Court case?
That was the whole issue in the case. The scope of employment was the whole issue. That's why Martinelli.
Was it a non-covered vehicle?
Yes, it was it's in the appendix, Judge. It was the same exact policy. It didn't apply. It only applied coverage to specifically identified covered autos in both Martinelli and both Medeiros.
And everybody agreed that she was in a non-covered auto?
Yes, in Medeiros, they were in a personal auto coming back from a Red Sox game. And Judge Indeglia in that case, based upon an affidavit of the wife of one of them, said, well, they may have talked business.
Still, ultimately, we have to do what the Supreme Court of Rhode Island would do, not what a Superior Court in Rhode Island has done. So what is there in Martinelli or Medeiros that suggests that reading of Martinelli is correct?
I think if you just look at the language, Judge, both Medeiros and Martinelli, the trigger, the crux is the scope of the employment. That's what triggers the class one. That's why they should be considered a named insured when a corporation is only the named insured. It's not the covered auto. It's, if you look at cases in many jurisdictions, there's coverage when they're not in a specifically identified vehicle because of the fact that they're in the scope of their employment. That's the whole purpose of that class one coverage that provides greater than class two coverage. That's the whole backdrop. If I can move to the second argument, which is irrespective of Martinelli, just a clear reading of the uninsured motorist statute requires coverage in this case. Initially, in opposing the or bringing the
Liability provision?
yes,
Yeah.
but for that liability provision, but for the employee as an insured endorsement, I could not make this argument.
What do we make of the significance of that insurance being only for liability?
Excuse me?
What do we make of the significance of that policy being only for liability?
By the policy itself, so the statute in Rhode Island requires if you provide liability coverage, you must provide coverage. Now, in moving for summary judgment, Travelers for the first time argued that its policy was not a primary policy. Under scaling,
I guess what I'm asking is, she's not trying to get liability coverage, right?
no, it's used to show that
If there's a policy that provides liability coverage for some cars and the kind of coverage she's seeking for other cars, is there precedent that suggests we then read the uninsured coverage statute to say, well, we just look past that distinction in the policy?
in Rhode Island,
Yeah.
none other than the statute, admittedly. There's a ton of cases, and I cited them in my brief, that says in very similar facts, same type of situation, non-covered auto for purposes, multiple cases. You got to have a symmetry between liability and coverage. Multiple cases, 8th Circuit, 10th Circuit. Now, admittedly, they're interpreting different states' statutes, but it gives an idea how the courts deal with these issues. Travelers cited one that went the other way. I think clearly the majority favors having.
So are you saying that there was no uninsured motorist or it was underinsured in this case?
It's an underinsured motorist.
Underinsured motorist.
It's clearly it's an underinsured motorist case. For several reasons, scaling initially.
The first predicate for that is this has to be primary insurance.
Right. In Rhode Island, under Rhode Island law, primary insurance is any insurance that by itself would provide coverage for an accident. Travelers wants to argue, well, primary means her own vehicle, her own insurance. That's not what the statute says. It says a primary policy. The word a is an indefinite article talking about something greater. The word "thus" is a definite article, which is narrower. So it's going for a broader interpretation. Secondly, the statute itself cites back to 3147-213.
Suggesting there can be two primary policies?
Oh, certainly. In insurance coverage, it's all the time, because then you would get into a battle of other insurance issues. Which coverage is primary? For example, for personal auto policy, it's not really the issue in this case, but says if there's other available insurance, we're pro rata. So certainly that's not the intent. You're not going to get into a case by case other insurance battle with applying the statute. The Rhode Island Supreme Court, obviously, by saying no policy insuring against with the Brown versus Travelers.
But you agree that liability provision is itself, the liability provision is not tied to the particular auto. Is that right?
Well, the liability, they provide the broadest of all coverage on all autos.
Exactly.
So that includes her vehicles are covered auto.
Their argument is, though, because it's limited to liability only, the statute doesn't kick in. Is that the basic idea?
Their argument, as I understand it, as well as Judge McConnell, it wasn't a primary policy. And you just can't interpret that in insurance law. I was mentioning about Rhode Island 3147-3. It actually defines an owner's policy. So if the intent of the uninsured motorist statute was to limit it to an owner's policy, the legislature would have used that. They could have very easily said no owner's policy, and it would have ended that, right? They didn't.
Thank you.
Thank you, Judge.
I just asked one last question, and let me just go back very briefly to the first argument. I'm still having some trouble when looking at the policy when the company marks symbol 2 as owned autos only. How do you get around that?
That's the whole purpose of Martinelli, right? So the whole purpose of Martinelli, as well as many other cases throughout the country where a corporation is the class 1 insured, some courts will say that language is ambiguous. The Rhode Island Supreme Court chose not to go that route, but instead came up with a policy exception if you could show that the employee was in the scope of their employment. So it's an argument by law, irrespective of the policy language. I don't disagree. You read that coverage
So even after Martinelli, policies are still including symbol 2.
Still using those individual language, family members. In that's why the Rhode Island Supreme Court said in the right case, it's appropriate. I would submit this is the best case that's been before the court. It's much better than Martinelli, Medeiros 1, 2, and 3. 1, she's in a covered auto for liability, and there's no doubt she was in the scope of her employment. If any case is going to apply, it would be this one.
Is this something we should certify?
I think so, Judge, because this issue is more important than just this case. It's a novel question in terms of the argument, in terms of the statute, in whether it applies to a commercial auto policy that restricts coverage only to owned autos. I think it's clear under Martinelli. Between Judge Indeglia's decision in the Supreme Court and Medeiros, it's quite clear that there's an exception in the nexus is the scope of employment. But I would agree that in terms of the argument that I'm making on the statute, that's a novel question, and it's going to have greater import than just this court. In fact, we have another case pending in Superior Court with Mr. Graceffer on the Martinelli issue, but that's in Superior Court.
And last thing, so I understand the theory that you're understanding. If it's not ambiguous, is the idea you cannot contract around that provision?
Yes, it's a public policy. That's what it is. Most jurisdictions would go the other way, finding the policy ambiguous. For whatever reason, in Martinelli, the Supreme Court, instead of finding it ambiguous, they made the policy exception. And again, the nexus is scope of employment. Thank you.
Counsel, at this time, would counsel for the appellee please put themselves on the record to begin?
Good morning, Your Honors, and may it please the court, Jessica Savino for the defendant appellee in this matter, Travelers.
You may begin.
Thank you. Your Honors, as my brother counsel admits, the plaintiff was not driving a covered auto in this accident. Her vehicle, owned by her personal self, was not defined under the policy as being a covered auto for purposes of coverage.
And that would be because of symbol 2. Correct?
Exactly, Your Honor. Under the terms of the policy for coverage, coverage is limited to autos that, quote, you own. You is specifically defined in the policy as being the named insured, which is the state of Rhode Island and various state of Rhode Island entities, not anyone else. The Supreme Court of Rhode Island has held it unambiguous in a number of cases that when you is defined as the named insured, it means the corporation. It doesn't mean the corporation's shareholders, employees, officers, etc. It means the corporation itself, i.e. the state of Rhode Island.
But it has to be a vehicle that the title is the state of Rhode Island. It can't be a state official who has a per diem and rents a car and uses it for that. It has to be specifically included, owned.
Correct, Your Honor. It has to be a vehicle that's owned by the state of Rhode Island.
In Martinelli, it was not owned.
Correct.
It was personally owned vehicle, just like this.
Correct, Your Honor.
Okay, and Martinelli has that language that, what was the named insured there? If it didn't say you, what did that policy say?
Make sure I understand your question, Your Honor. The named insured in Martinelli was the corporation itself.
So here the language is you?
Correct.
And that's the difference?
So no, maybe I misunderstood your question, Your Honor. So in Martinelli, the policy language was to be an insured, you had to be, just as in here, in a covered auto, or you had to be you. Just as in here, there was no dispute in that case.
So when Martinelli has that language that maybe it also applies to employees, what do you understand Martinelli to have been talking about?
Certainly, Your Honor. So Martinelli didn't only just say that there might be possibilities in different circumstances where coverage might apply. They also said that it might be eligible for coverage under some policy that listed a corporation. It didn't say what that policy language would need to include. It didn't, in making that holding, state that if the shareholder in that case had been in the scope of his employment, that he would have automatically been named insured. That wasn't their holding. Their holding was that there could be some circumstances and also some undefined policy language. And when you put those things together, we could lead to a conclusion where there might be coverage. But that wasn't that case.
Why would they say that? I mean, that seems completely superfluous if this particular language didn't have some meaning to them. And then in the Medeiros cases, at least one justice recognized it as an exception.
Certainly, Your Honor. So respectfully, I disagree that they were saying that that language itself meant that there was an exception. I think the suggestion there was that different policy language and different circumstances put together could create a situation. Perhaps it's because that you is not so clearly defined. Maybe you could be defined in a policy in a more ambiguous way, so it wasn't so clearly just the corporation itself.
Well, in
That's
Medeiros, didn't they repeated it, right?
No. And that's where I must respectfully disagree with my brother. In Medeiros 1, the court did not reaffirm the existence of this exception. They never even used the phrase Martinelli exception. They merely noted that the court in Martinelli had suggested that there might be circumstances in which an employee in the scope of his employment could be considered an insured.
But that's mentioning Martinelli and repeating, isn't it?
It's mentioning that the possibility had been raised. It's not saying that such a possibility exists. And they further.
And then Medeiros applied it on remand in a circumstance just like this. Is that right? Or is that you disagree with that too?
I disagree.
Okay.
So in Medeiros 1, the court noted that the court had suggested there might be such a circumstance. In Medeiros 2, that court merely noted that in Medeiros 1, they had noted that there might be such a thing, but not gotten to the question. And then in Medeiros 3, this is the only case in the entirety of Westlaw that uses the phrase Martinelli exception, a trial court case. And the court there even simply suggests that this might be a thing. And because it might be a thing, then it created a question of fact. There was not a definitive ruling that this is always a thing.
Correct. But the thing it understood that to apply to is this type of case, right? In other words, even though the person was in a personally owned vehicle, and even though the policy only applied to covered autos that didn't include such vehicles, it acted as if the Martinelli exception, to the extent it exists, would cover such a circumstance. And then the fact question was, were they in the scope of employment? That much you agree with, right?
I agree that the court there was treating the scope of employment as a factual question because of the possibility.
Whereas on your view, nothing in Martinelli supported that treatment by the Superior Court.
Exactly. I think the court in Martinelli was making almost an offhand remark that there could be different situations where this happened.
But if there was no possibility, which is what you're arguing, then why would they say that that particular factual dispute had any relevance to anything, whether they were in the scope of their employment or not? Because if it was irrelevant, that wouldn't matter.
So I'm not saying that there's no possibility ever that such a situation could occur. And I think that's the.
Yeah, but what is about the policy there that you're saying is different from the policy here that made it relevant there?
So I think the language in Martinelli was the same language, and that's why it wasn't that case. But their acknowledgement that there could be different language that could lead to a different result is why they.
They just include that to narrow the scope of their holdings. They were not addressing other cases.
Exactly. They're
not saying this language would apply in a different case.
Exactly. Both Martinelli and all the Medeiros cases were interpreting the actual terms of the policies in front of them. All the policies in front of them, if it was you, it was the named corporation.
But if the scope of employment was relevant to the policy that for them, then it meant that the policy led to the possibility that there was coverage if there was scope of employment.
I don't think that they were saying that that was the case in Martinelli. That was the argument put forth by the plaintiff.
In Medeiros.
In Medeiros.
In Medeiros, the scope of employment issue was relevant to the court's decision, but scope of employment wouldn't have mattered if the policy wasn't open to an interpretation that there was coverage.
In Medeiros 3, the court did suggest that it could be relevant whether or not he was.
That's the only,
but that was the
one
trial
of
court.
Medeiros cases that said that. The two
Exactly.
Rhode Island Supreme Court Medeiros don't say that.
They interpreted the plain language of the policy. They looked at the literal language. They found the literal language to be unambiguous, that you was not the claimant in that case, and that's what they based their decision on. Those two cases that looked at just the literal language were the only two Supreme Court cases. Medeiros 3, the only case to ever use this Martinelli exception phrase and suggest that it might be a relevant consideration, was a trial court case.
If we took your attention to the liability provision, which is not limited to a particular auto and does provide this employee liability coverage for that auto, what's your answer to the contention that just for that reason alone, we have to apply the uninsured motorist coverage statute to say, well, if you're going to give that coverage, then you've got to give this coverage too?
Certainly, Your Honor. So my brother is correct when he said that there was no case law in Rhode Island upholding his position. However, there is case law upholding my position on this matter. The Supreme Court of Rhode Island has held on several occasions that the uninsured motorist statute governs only the extent of coverage that must be provided to the policyholder. It doesn't dictate who needs to be covered under certain parts of the policy.
But it does dictate it once you've decided to give them the kind of coverage that triggers the statute, right?
Respectfully, that's limited to it. The court has interpreted the language of the statute just as strictly as it interprets the policy itself. And so the court has repeatedly upheld policy language, which affords liability coverage to someone not the named insured, but someone who's afforded coverage because they're a family member of a named insured, while also excluding them from uninsured motorist coverage. So that the court has made this decision on multiple. So first was Mello versus Aetna. That in that case, the plaintiff was on his mother's policy because he was a family member of the named insured. And the court there held that, quote, neither the statute nor the public policy expressed therein mandates what class of persons must be extended coverage, nor do they disallow any restriction on that class. Then 10 years later, and
just so I understand, in that case, the family member had been given what kind of coverage under the policy?
the family member was entitled to liability coverage under the policy.
And they concluded that giving liability only didn't trigger the statute?
Correct, Your Honor. They found no violation of the statute in that matter because the person that was being offered under one part of the policy was not the named insured. He was just insured for that purposes of liability coverage. He was the named insured's son. And so they held, they've also held in.
Well, I'm trying to understand exactly what the ground of distinction. Is it that the named insured only got liability coverage, or is it that it wasn't the named insured?
It wasn't the named insured.
So here it is the named insured.
No, the person at issue in that case was not the named insured, and the person at issue in this case, the plaintiff, is not the named insured.
Well, is that true for purposes of the endorsement provision that gives them liability coverage? You'd say yes, because the named insured is the one who has the policy, is the idea?
The endorsement that gives them coverage for liability purposes only. It makes them an insured for liability purposes, even if they might not otherwise be. In both in Mello versus Aetna and then 10 years later in Delagrado versus Liberty Mutual, the court makes that distinction. In both of those cases, the person bringing the claim was not the named insured, but because of the policy language, and specifically language that allows you to be considered a named insured as long as you're a family member residing with the named insured, then they were entitled to liability coverage, but they were still allowed to be excluded from uninsured motorist coverage. First, in one circumstance, because the car was not a covered auto, and in another circumstance, because it was her own vehicle that was not listed on the policy, was listed on a separate policy. And the court went on in De La Grada to uphold where it was the husband's policy. So again, the wife was covered for liability purposes, that the statute does not mandate that uninsured motorist coverage be extended to vehicles that are not covered under the policy. The court has repeatedly reiterated that uninsured motorist coverage is attached to a vehicle. It's
Right, but I'm just still not, I'm not sure I'm tracking everything. This liability provision does apply to this vehicle.
the employees as insured endorsement only applies to liability coverage.
Correct.
Anyone who would be entitled to liability coverage, but it doesn't mean that you're automatically an insured for uninsured motorist coverage when you're not in a covered auto. And the endorsement doesn't make you a named insured, it makes you an insured. Just the same circumstances as was the claimant in Mello in De La Grada. The court has made clear that the intent of the statute is, quote, for protection to be given to the named insured against economic loss resulting from injuries sustained by the
Just help
negligent
me out.
operation.
How do I know who the named insured is and who is just an insured?
The named insured is very clearly defined on the policy. It's completely unambiguous. It's U equals the name insured. The name insured is on the top of several different endorsements and attachments as name insured equals state of Rhode Island.
What text in the uninsured motorist statute tells me that this distinction between named insured and uninsured matters?
Well, Your Honor, the policy insuring against loss in that statute is directed towards policies that provide coverage for the insured motor vehicle. So I think we have to turn the attention back to the vehicle itself. There is no policy providing primary coverage for the insured vehicle if there is no insured vehicle. There is no covered auto. The plaintiff's auto is not.
In other words, is it the fact that the statute's for loss as opposed to liability?
I'm sorry, I'm not sure if I understand your question, Your Honor.
She has liability coverage under the.
Correct. Yeah, I believe that's undisputed.
But that's all she has.
Correct.
Does the uninsured motorist policy refer to what kind of policies is that statute talking about?
The policies under the uninsured motorist coverage are for a policy insuring against loss, which is a defined term, meaning a policy providing primary coverage for the insured motor vehicle. Under the statute here, this is not the insured motor vehicle. She's only autos owned by the state of Rhode Island are
I'm trying to
insured.
figure out what's the text that's telling me that since the endorsement provision refers to the liability coverage applying to this vehicle, what's the text in that statute that tells me, yes, even though you have liability coverage for this vehicle, what we care about is your coverage for the other vehicle?
With all due respect to our friends in the legislature, I think the statute is rather unclear. And for that reason, we have to look at the Rhode Island Supreme Court interpretation of the statute.
That's where you say
Their interpretation,
et cetera.
exactly, their interpretation has been that it applies to the named insured, and they have repeatedly upheld exclusions of just an insured under the liability part from the uninsured motorist part.
And what are your thoughts about certification?
Sure, I think the policy language is clear. This can be answered as a contract interpretation question, and I don't think certification is necessary.
Let me ask you another question. I note that the Martinelli case was decided in 1996, the Madeiras, three opinions, 2002, and then 203, 203. And since then, Travelers, which I understand one of the largest and oldest insurance companies in the nation, has had symbol 2. And I'm sure other insurance companies also have the equivalent symbol 2. So my question is obviously this is not legal precedent, but isn't that custom and use perhaps demonstrate how insurance companies throughout these last 20 years have interpreted those decisions?
I think actually just the opposite, Your Honor. If you look at the other choices for coverage, I think it's telling the choice that the state of Rhode Island did not select for the purposes of uninsured motorist coverage. They didn't select choice number 9, which would be non-owned autos that are used for your business. If an employee was meant to be considered an insured automatically if she was in the scope of her business, having such a choice would be superfluous. There would be no need to distinguish between vehicles in the scope of your business. First, it would be the exact same definition as just any auto. If it just has to be
So
an
Rhode Island could, like you said, under symbol 9, filled that box, and then the plaintiff would have been included.
correct. I don't think that's in dispute, but Rhode Island did not select.
And I guess it's a policy decision that the state has, for example, it could be, we don't want to risk people in, working, but then we have to determine if they're actually working or not working, and just let's not cover those cars. That's Rhode Island's decision, correct?
Correct, Your Honor. I think it was meant to make it clear it's either our vehicle or it's not our vehicle. And Rhode Island didn't want to, open itself up to liability exposure by not having various vehicles covered under liability when it could potentially have some sort of vicarious liability for the driver. But that doesn't mean it wanted to open itself up to claims for every employer, doing something all the time could make a claim against their policy instead of their own auto policy, which would have their.
If there were, let's assume an allegation by Ms. Thornton, for example, saying, well, the state, I don't know, I didn't see the policy, but the state was encouraging me to drive, my own vehicle, XYZ. From traveler's perspective, that's not an issue. It would be an issue between, she would have to, I guess, sue perhaps the state or something else, not travelers.
Correct. Or she could bring a claim under her own auto insurer, which every policy that's going to require you to have, or is going to allow you to have coverage because of some tangential relationship, your own policy as well. And Miss Roberge in this case did have her own policy with uninsured motorist coverage, and I respectfully submit that that's the policy intended to cover her in such a situation, as uninsured motorist coverage is not meant to be the equivalent of liability coverage.
Okay, thank you.
Thank you.
Thank you, counsel. At this time, counsel for the appellant, please reintroduce yourself on the record. To begin, you have a 2-minute rebuttal.
Thank you again, Jim DeAmbra on behalf of the appellant. To answer the Judge Barron's question about the scope of the statute, it clearly says no policy ensuring loss resulting from liability. That's what the employee and as an insured endorsement did. It created liability coverage.
What do you make of the precedents that your opponent was citing to us, saying that it's been construed?
Those are totally different cases. They have not cited one case.
What's different about it?
Those cases were cases like, for example, in this case, where there's no doubt that the vehicle was covered for liability coverage. Our argument is they're required, because the vehicle's covered under the statute, to provide It's not an exclusion. Though,
Son, that they were.
yeah, that was
Clear that the
no.
car was covered for liability?
It was, but it's totally it's the exclusions were different. Then it wasn't this type of case. It was, for example, Della Grata, Mayo. Those were exclusions dealt with owned but not insured if you're in another vehicle at the time. There's many other exclusions, but in this case, there's not one case from the Rhode Island Supreme Court that says if there's liability coverage, you can exclude because there's no question she was an occupant of the vehicle.
And
in those other cases, they weren't occupants.
You make of the named insured versus uninsured distinction?
Well, that's the whole basis of Martinelli, the named insured, because you can't have a corporation suffer bodily injury. So a named insured has higher rights under a policy than a regular insured under who is an insured. And so that's the whole basis of Martinelli, why they're extending the coverage, coverage, to non-owned autos if they're in the scope of their employment, because they should be considered the named insured, because employees, officers, who else is going to get that benefit? Lastly, if I could, Judge, when counsel indicated in Medeiros 1 and 2, the Supreme Court did not address the Martinelli exception. If I can read very quickly from Medeiros 2, that's the Supreme Court case, 822 A. 2nd 175. It says, in Medeiros 1, we affirm judgment because absent any evidence the defendants were acting in the scope of their employment after the corporations when the accident occurred, summary judgment was proper. That's the Martinelli exception. They addressed it, they applied it. In that case, Medeiros 1 and 2, there was no evidence of scope of employment, whereas in Medeiros 3, they were able to show before Judge Indeglia scope of employment. Thank you for your consideration.
Thank you, counsel. That concludes argument in this case.
We'll take a 3-minute recess, Dan.
All right. Court is now in session.
You may be seated.
Judge, I'll go ahead and put this back on the record.
Please do.
The next case, number 23-8019, In re James Hayes. At this time, would counsel for the respondent please introduce himself on the record to begin?
Edward Weist for the respondent.
May begin.
May it please the court. This is a reciprocal discipline proceeding based upon action by the Supreme Judicial Court in February as against James Hayes. I remind the court that it is a plenary review for purposes of discipline in this court. The disciplinary rules specifically provide essentially this court will, with the respondent having the burden of persuasion, look to see in particular whether substantially similar discipline should be supplied, or where will be gross injustice, or whether there is an infirmity of proof, again, in our position being supporting the extreme remedy disbarment imposed upon Mr. Hayes. I think we have two principal arguments to make. One would be under disciplinary rule C3, going substantially similar in this court. It was characterized in the SJC that this is a case where Mr. Hayes found himself representing in a child support dispute, frankly, a client whose principal goal was to avoid paying child support under any circumstances. When it came to the bar overseers 2 years later for the first time, the request for investigation, that was Exhibit 56, I believe, in the SJC, basically was a list of fees he questioned, was raising questions concerning documentation, raising questions concerning communication. The word fraud was never found in there. In fact, if you look at both requests for investigation, 56 and 57 in the court below, it was always conceded what became the major sticking point in the fraud claim. Was there a transfer, or was there ever a transfer between the client and his brother of half of lottery proceeds, which could be applied to child support? Basically just took it as a given without attributing that fraud, that potentially fraudulent conveyance to Mr. Hayes. This is a fee dispute. This is a client breakdown dispute. It turned into a disbarment. We would contend that given 40 years of service at the bar, substantial public service, that's in the affidavit submitted with the paper.
Have you exhausted all of your avenues before the SJC, or
Yes.
There's nothing pending? There's no reconsideration pending at this point?
The disbarment was effective as February 2023. I think the docket says it was called to this court's attention in May of last year, and it's being argued now. And again, under the procedure and disciplinary rules, the court learns of it, issues an order to show cause. Eventually, a hearing takes place.
No, but I think Judge Thompson's question is, are there any further pending proceedings before the SJC?
No,
like
the
reconsideration?
SJC proceeding closed effectively in January 24.
And there's nothing else available?
What?
There's nothing else available at the SJC?
Nothing else available under ordinary procedure. In theory, one could always apply for modification, but certainly nothing under the ordinary.
Or he could apply for reinstatement again.
That is one of the issues. Disbarment means 8 years. A term suspension, and again, we are not going to argue at this point the engagement agreement, which the SJC found to be highly questionable, the failure to follow procedures required by IOLTA, which were specifically endorsed by the engagement agreement. We're not going to suggest at this point that they could not have formed a basis of discipline. What we're suggesting, though, is if you look at other similar cases where the only issues appear to be fees and client breakdown, and I'm citing specifically DiViacci in 475 Mass 1013, in 2015, 27 months for a client breakdown. Frankly, client abandonment, and unfortunately, I'm afraid Mr. DiViacci's name is well known for having not succeeded in getting himself reinstated the last 9 years. And the Zankowski case, which was
in the decision, it says similarly, this case is no ordinary excessive fees case. Hayes did not merely pad his bills, but preyed on a vulnerable, unsophisticated individual. He had Lamarche sign a shocking predatory fee agreement and power of attorney, giving himself sole discretion to pay himself any amount he chose from lottery winnings, blah, 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 blah.
I'm not here to defend the fee agreement at this point.
No, but I guess I'm saying for purposes of the comparison point where you say it's just client breakdown, this is language specifically addressing that point by saying this is not an ordinary case.
It was not an ordinary case in many ways. The context in which Mr. Hayes was litigating the case in probate court from roughly October 2013 to roughly January 2014 was for a client who, yes, who has serious impairments. And one of the impairments Mr. Hayes was concerned about, as he testified, was his client his client who had burned through the child support money, perhaps before, perhaps after an injunction was issued freezing further expenditures of that money, having transferred half of it to his brother, and what we would contend would have been a previously agreed partnership. What was he testified to later, the advice of Mr. Hayes, which we believe was inconsistent with every other piece of testimony in the case, was that his immediate concern was that there not be a probate court contempt, which would lead to a client with, as recognized in both the single justice and the panel opinion, serious manic depression problems. If you're in a suicide risk, if you a 1%, a 1% risk of imprisonment with a 5% risk of suicide was too much, and many of his actions were taken, perhaps ill-advisedly, to prevent that at all costs. Again, our concern is that because of one line of testimony of Mr. LaMarche's saying that Mr. Hayes was the creator of the transfer of half the funds to his half-brother, that somehow the entire case was tinged with fraud. Now, our contention, and again, this perhaps goes to disciplinary rule C2, is that, in fact, notwithstanding the rule that ordinarily a hearing committee and the SJC can determine the credibility of witnesses, taken as a whole, the testimony was incredible. Taken as a whole, it tinged the approach to the rest of the case. It turned a fee case and a IELTA non-compliance case into a fraud case inappropriately.
So just so I understand, if we didn't agree with that,
What?
if we did not agree with you on that point, and I understand you're making an argument that we should, do you then think if we read the record as the SJC read it, that they're wrong to say this is like Zach and Croson?
Again, I would say, with the burden of persuasion being upon Mr. Hayes, that this, disciplinary rule 2 and Williams suggests that this court at least has the power to look at the record.
Yeah, no, I'm asking I understand the point that if we characterize the record and viewed the record differently, that might affect things. I'm just asking, if we accepted the characterization the SJC gave, are you disputing that the case is then equivalent to Zach and Croson, as the SJC said?
Again, I would ask that, this, again, I think Williams suggests this court is never, the opinion of the SJC in this court per Williams has persuasive authority. It is entitled to respect. It is not controlling. That it is this court's responsibility to look at it separate, look at it independently. And we are looking here at, again, if this is a witness who testified not only that his client, that Mr. Hayes was the originator of the alleged fraud upon the probate.
You would be asking us to make a different credibility finding or a different determination?
I think that I would submit that if you look at, again, Rule C4 says, you can make a different decision as what is appropriate discipline. Rule C2 talks about an infirmity of proof. Again, I'm not going to argue that the rules of the SJC says the hearing committee controls on credibility. I'm not going to argue that that means that that you have a right to accept the SJC's finding on credibility, even though I believe, and as we argue under the Hayes case, what credibility inconsistent with every other piece of evidence is not credibility. That again, all we are suggesting, and this is a matter perhaps, even if it's only a reputational harm, SJC essentially, as it always does in discipline cases, balancing protection of the public, protection of the system against the possibility of rehabilitation for a lawyer. In this case, when completely, essentially said this lawyer was beyond redemption on the basis of findings of law, which were actually, we contend, contrary to the actual language of the disciplinary rules, contrary to discipline applied in cases with the same factual result in terms of the relation between the client and the attorney. And at the very least, the word disbarment ought not to be used in this court, and this court has the power not to impose the word disbarred.
So what are you looking for?
I would love exoneration. We're not going to get that. If I would, again, our suggestion would have been, as we argued before the SJC, that at least as of record, it be deemed a term suspension, nominally, again, looking at the other cases we refer to, perhaps in the 2-year range. I don't know, and I'm not purporting to ask what, after a suspension with pending disbarment, my client's privilege in this court would be. He does have immigration practice, he does have practices outside the district court, and certainly outside the Massachusetts state courts.
For immigration practice, he doesn't have to be a lawyer.
I understand that, but I believe, I'm just not going to express an opinion as what the immigration rules have to say about appearing as a counsel in immigration cases. Once if you're.
Let me also ask you, so what you're suggesting is if we impose some sort of reciprocal discipline, that we be more lenient perhaps than the SJC?
Yes. That at this point, I said ideally it'd be an exoneration. At this point, I'm not going to ask you to ignore the findings vis-a-vis the documents within the record, which again, they are what they are.
What also, just to have an idea, your client, he's been admitted to this court, I think, for almost 40 years. Has he actively practiced here, regularly practiced, or is he just admitted? And
since I will acknowledge that during the pendency of proceedings before a complaint was filed, I believe, I did sign his application. It was in connection with representation in one immigration appeal, which might have come before this court, but again, that would have been the limit of his practice before this court.
Okay, thank you.
Mm-hmm.
What about the district court?
What
about the federal district court?
The record will show that he did not object to the show cause filed in the district court with respect to discipline.
So he's been disbarred by the Massachusetts District Court.
Yes, that's of record. I thank the court.
Counsel, that concludes argument in this case.
All rise. The session of the Honorable United States Court of Appeals now recessed. God save the United States of America and this honorable court.